Field hearing of the Senate Health, Education, Labor, and Pensions Committee will be called to order. This hearing will focus on whether our federal laws are doing enough to protect people when they are at their most vulnerable, when they are sick and in need of medical care. Being in the hospital, even under the best of circumstances, is a stressful experience. When you or someone you love are in urgent need of care, nothing else matters. I think everyone has had the experience of powerlessness and vulnerability when you're in pain and you don't know what's wrong, or when your child or your parent or your spouse is hurting. And at that moment, the last thing on your mind is your wallet. That's why I found Attorney General Lori Swanson's report about Accretive's alleged activities at Fairview extremely disturbing. I would find it absolutely abhorrent if any patients had been badgered by debt collectors in the emergency room, or if any patients had been given the impression that they wouldn't be seen unless they prepaid for their care. That type of activity is not acceptable anywhere, and is certainly not acceptable here in Minnesota. I've read that patients in extreme pain were asked for payment for health services in Fairview's emergency room before they even knew what was wrong with them. And I've heard that parents of premature infants were approached about their bills while they were in the neonatal intensive care unit. I've even heard that off-site debt collectors had access to detailed protected health information about patients, including their mental health conditions and other diagnoses, which may be in violation of federal privacy laws. And I'm worried. I'm worried that if patients know they'll be asked for prepayment of services, that they'll stop going to the emergency room when they're sick, which isn't just dangerous for them, but it could result in the spread of disease and entire communities getting sick. And I'm worried that if patients hear that their protected health information isn't going to be kept private, that they won't share important information with their doctor, such as what medications they're taking. And that could lead to even worse health problems and higher costs if doctors don't have the information that they need. I'm worried that activities like the ones that have been alleged could bring down the quality of health care that Minnesotans receive when they go to the hospital. And that would be a real tragedy. Our state has always been a national leader in providing high-quality health care, and Fairview Health Services is a prime example. I've visited Fairview hospitals many times, and I've spoken at length with their doctors and their nurses. I'm convinced that they are among the best health care providers anywhere. And I think we'll hear from people today who will bear that out. But I also know that there's another part of the equation dealing with the administrative side of things, and so I look forward to working with Fairview and all of Minnesota's healthcare leaders to make sure that patients are fully protected. It's possible that the laws that protect consumers from debt collection and those that protect our privacy don't go far enough. And although we're still getting all the facts about the activities that may have taken place, I look forward to hearing from our experts about whether we need to strengthen the laws that protect us when we are at our most vulnerable. However, before we can move forward in strengthening never mind, I won't drink from the flat water. Before we can move forward in strengthening our patient protections, we need to understand what took place. And that's why I've called this hearing and asked our witnesses to testify today, because I want to hear all sides of the story. I'm not here to sit as judge or jury. I'm not here to resolve the dispute between Accretive and the Attorney General. That will be left to the court system. But I do want to find out what happened to the best that I can, how patients were affected, and whether existing laws are doing enough to protect Minnesotans when they go to the hospital. Take the Health Insurance Portability and Accountability Act, or HIPAA, for example. That law is intended to protect both the privacy and the security of patients' sensitive health information. In this case, though, nobody disputes that data from more than 20,000 Minnesota patients were compromised. And it appears that debt collectors had access to more protected health information than they needed to perform their jobs. So that raises questions for lawmakers. Does HIPAA need to be strengthened? Does it require clarification? Is it being enforced adequately? Take the Fair Debt Collection Practices Act as another example. That statute puts in place important protections for consumers. It governs when and how debt collectors may approach a person about a payment. But there's a dispute in this case as to whether that law even applies to Accretive's alleged activities. Again, it will be for a court to resolve that dispute, but again, there are questions for lawmakers here. For example, are federal statutes sufficiently broad in their coverage to protect Minnesotans from abusive debt collection practices? And finally, there's the Emergency Medical Treatment and Active Labor Act of 1986, or EMTALA, as it is known, which was put in place to prevent the practice of patient dumping, where hospitals would turn patients away from the emergency room if they were unable to pay for their care. The idea here was that anyone who desperately needs help should get it regardless of their ability to pay. And I think it is important to remember the underlying goal of this law is to provide emergency care to everyone who needs it. I know that hospitals across the country are being squeezed right now. Reimbursements are low, costs are rising every year, and budgets are tight for everyone. And hospitals, particularly hospitals here in Minnesota, which provide such high-value care, deserve to be paid for the services they provide. But especially in this time of economic hardship, we have to make sure that those with the least voice are heard, and that patients aren't the unintended victims of budget shortfalls. And that's what we'll be hearing about today, whether patients are being protected and what we can do better to protect them. Now I'd like to introduce our first panel of witnesses. Lori Swanson is Minnesota's Attorney General, the first woman ever to hold that seat. She was elected in 2006 and re-elected in 2010 and has been named one of the top 10 lawyers in America by Lawyers USA in 2009. She previously served Minnesota as Solicitor General and Deputy Attorney General. Mike Rothman was appointed the Minnesota Commissioner of Commerce in January of 2011. Like the Attorney General, Commissioner Rothman has extensive experience with consumer protection issues prior to his current role. Commissioner Rothman was an attorney with Winthrop and Weinstein, PA, in Minneapolis. Thank you both for being here today. Please proceed with your testimony. First, I'd just like to take a moment to remind all witnesses to stick to 5 minutes of testimony today, although, as you know, you may submit your statements for the record. We're going to have someone, Catherine here, holding up some time warnings just to let you know, because we do have a lot of witnesses today and we want to get through this. So thank you, Attorney General Swanson, and please go ahead with you.
Well, Chairman Franken, thank you for expressing so much concern and compassion for America's patients and for holding this hearing, especially in Minnesota, where so many patients and Minnesotans can have the opportunity to participate. You know, charitable healthcare organizations in Minnesota, they get a lot of breaks from the taxpayers of Minnesota. They don't pay income taxes, sales taxes, property taxes. They get the privilege of issuing tax-exempt bonds. And so over the years, the Office of the Minnesota Attorney General has had a strong focus on whether charitable hospitals and healthcare organizations in particular operate in a manner consistent with their charitable tax-exempt status and duties. Following a compliance review of Fairview in 2005, which found that the hospital engaged in overly aggressive collection practices, our office entered into a court order, consent decree with the hospital to reform and modify its billing and collection practices. We entered into a similar consent order with North Memorial as well as other hospitals. More recently, we initiated a compliance review of both Fairview and North Memorial to evaluate their compliance with the consent decree and also whether their conduct was consistent with the duties and responsibilities of tax-exempt charitable hospitals. At Fairview, we examined the delegation of management activities by a charitable hospital to Accretive Health, a for-profit Chicago company. The Fairview compliance report is complete. One of your next witnesses is Chuck Moody, the Fairview chairman and soon-to-be incoming interim CEO. I've worked with Mr. Moody over the last several months and can tell you that I believe he's in command in addressing our concerns and has great concern and empathy and compassion for the patients of Fairview. The compliance review of North Memorial is underway. The Fairview compliance review found that Accretive repeatedly ignored the court order between the hospital and the Attorney General. This chart is an email from an Accretive manager asking its collectors to sign an agreement that they were familiar with the court order, but then telling the collectors, don't worry, the court order won't change their behavior anyway. It's just so we can say we have it. This chart is a Fairview issues log from the very same month, finding that Accretive tried to collect money from patients who were current on their payment plans, that it sent 6,000 accounts to collections without ever asked a patient for payment first, and that it sat on 300 payments made by patients, resulting in artificially high bills. This chart is from a Fairview internal audit in May of 2011 that found numerous violations by Accretive of the consent decree. This chart is a Fairview email to Accretive from September of 2011, advising Accretive that it was in violation of the consent decree, that its actions were resulting in numerous patient complaints and confusion for patients, and saying, we're not going to be able to keep doing business with you. This chart is from another Fairview internal audit in December of 2011, concluding that Accretive continued to ignore the consent decree and that it had violated the debt collection laws and the patient privacy laws. Senator, it's apparent from the compliance review that number one, Accretive thought it was above the law. Number two, that Accretive's management contract unduly incentivized the company to ignore the cultures and mission and duties and values of a charitable hospital organization. And three, that the hospital was unable to restrain Accretive. I'm going to focus in the interest of time on just one area of the compliance review, and that's bedside collection visits in the emergency room. Chairman, 20% of Americans face a life-changing event in an emergency room. It's where husbands lose their wives, wives lose their husbands, kids lose their parents, and parents lose their children. It's a place of both medical trauma and emotional suffering. It is a solemn place, and it should be and remain a very solemn place. This chart shows that Accretive differentiates itself from other companies with what it calls the Accretive secret sauce. And it uses words, very frankly, Senator, that are not befitting for a hospital or an emergency room, that are insulting to the patients. The document concedes that typical hospitals don't collect money in the emergency room. It then describes, though, the placement of collectors in the emergency room as one of Accretive's secret sauce ingredients. Now, I've personally met with about 25 patients who were hit up by the Accretive secret sauce. My office has interviewed and spoken with many others. About 20 of those patients and their families are sitting here today behind me, and I want to thank them for coming and being part of this hearing. Senator, 201, they're here because they don't want any other patient in America to ever be subjected to the kind of tactics to which they were subjected. We've heard from patients who receive bedside collection visits in the emergency room while suffering from chest pain, strokes, blood clots, labored breathing, diabetic attacks, appendicitis, elevated heart rates, elevated blood pressure, kidney stone attacks, disorientation, and even while hemorrhaging blood. Some were asked to pay money while they were in so much pain they thought they were going to die. Others were asked to pay money while dazed and confused and disoriented. Some were asked to pay money while hooked up to morphine drips, heart monitors, IVs, or with tubes shoved down their throat.
I'm sorry, Madam Attorney General, but we are through your 5 minutes. Could you wrap it up real quick?
Yes, I will wrap it up. Many were laying undressed on a gurney in pain. Most had insurance, yet they were still asked to find their credit cards or checkbooks while suffering in the emergency room. Some were overcharged because the secret sauce aimed high and demanded that they pay too much money, and some had to fight for refunds. Others were surprised to be stop-listed on early morning hours before their surgery while weak and suffering. Mr. Chairman, there is a time and a place to collect money, but what these patients went through is not the right time or the right place. Our office doesn't enforce EMTALA, but we do regulate charitable organizations in Minnesota. Accretive's management contract unduly incentivized the company to scorn the culture, mission, and values of a charitable hospital. It's not appropriate for a management company to orchestrate this type of collection conduct at a charitable hospital that receives tax exemptions from the people of Minnesota. American patients deserve better. And Mr. Chairman, I thank you again for holding this hearing.
Thank you. Attorney General Swanson. Commissioner Rothman, please go ahead with your testimony.
Thank you, Mr. Chair. My position as Commissioner comes with important responsibilities of protecting consumers and the public interest. Specific to today's hearing, the Commissioner of Commerce has the powers and duties and responsibilities under Minnesota law to regulate collection agencies. Under Minnesota law, any collection agency doing business in Minnesota first must be licensed by the Department of Commerce. A collection agency must be a financially responsible entity, and any person wishing to act as a debt collector in Minnesota must register with the department. Minnesota law also sets forth a regulatory scheme for debt collection practices and activity. To maintain licensure and compliance with state regulations, no collection agency or collector shall engage in any of the following prohibited practices, among others. Use or threaten to use methods of collection that violate Minnesota law. Communicate with consumers in a misleading or deceptive manner by using instruments which simulate the form and appearance of judicial process. Violate any of the provisions of the Fair Debt Collection Practices Law, the federal law, in collection letters or publications, or in any communication, oral or written, imply or suggest that healthcare services will be withheld in an emergency situation. When attempting to collect a debt, fail to provide the debtor with the full name of the debt collection agency as it appears on their license. The public has entrusted the department to enforce these regulations, and law-abiding debt collectors rely on us to ensure fair competition in the marketplace. These laws and our consistent enforcement of them are a crucial line of defense for Minnesotans, meant to protect their rights and dignity. The protections are particularly important for the most vulnerable among us, the poor, the sick, the disabled, the elderly, and those facing urgent health care needs. When our department receives complaints about unlicensed collection activity or other consumer issues, our staff works to carefully determine the merit of the complaints. When warranted, the department's review may move to the stage of a formal and comprehensive investigation, which may result in consent orders, formal statement of charges, administrative hearings, or settlements. With respect to Accretive Health, the Commerce Department has begun a thorough investigation of allegations that the company and its employees were conducting prohibited collection activity and had allegedly gone to great lengths to disguise its role as a collection agency from consumers. I directed the Enforcement Division at the department to look into these allegations to determine their merit and pursue a formal investigation. Allegations investigated by the department were based on the extensive complaint filed by the Attorney General. These allegations of unlicensed activity and prohibited collection practices raised serious concerns, and the Commerce Department exercised its regulatory authority to promptly put a stop to this activity in Minnesota. After an initial investigation, I signed a consent cease and desist order on February 3rd, 2012, that was agreed to by Accretive Health to summarily terminate any further collection activity until its collection practices came into full compliance with Minnesota law. Specifically, the consent order directed Accretive to, first, cease and desist from any further activity requiring a collector's license in Minnesota until it meets certain specific conditions, including full compliance with Minnesota law. Second, to provide copies of documents and evidence regarding communications provided to debtors in their attempts to collect debts, their screening process for hiring employees, training materials, and the policies and procedures for protecting personal information. The cease and desist order agreed to by Accretive Health was an important first step in ensuring the full protection of Minnesota consumers in response to these troubling allegations. We have a continuing full and detailed investigation. The details relating to this ongoing investigation are classified as private until the investigation is complete in accordance with Minnesota Chapters 13 and 45 under our statutes. The investigation will require, though, the full cooperation of Accretive Health. False and deceptive collection practices from any collector or collection agencies, licensed or unlicensed, will not be tolerated on my watch. I want to make it clear that to the extent the evidence collected in our investigation substantiates these allegations, such allegations would represent a severe and troubling disregard for consumer rights and a clear violation of Minnesota law. Mr. Chair, I appreciate the time. We take all our responsibilities seriously, and I am pleased to answer any questions.
Thank you, Commissioner Rothman. Attorney General Swanson, thank you for your testimony and for providing us with background on your investigation, which has garnered quite a bit of attention. I think that's probably because just about everyone needs medical attention at some point in his or her life, so these issues affect all of us. I know you've worked extensively with nonprofit hospitals across the state, and as you note in your report and in your testimony, nonprofit hospitals qualify for exemptions from all these different taxes that you laid out. In order to qualify for these tax exemptions, nonprofit hospitals are subject to specific federal and state requirements. Could you tell us about the agreements that you developed with hospitals across the state to make sure they're providing a benefit to the community?
Yes, thank you, Chairman Franken. In 2005, I think every single charitable hospital in Minnesota signed an agreement with the Attorney General's office, which was then renewed in 2007, and which we are in the process of renewing again for a 5-year period. That agreement was entered into after we did a compliance review that found troubling conduct, overly aggressive collection practices, and the agreement requires that hospitals have in place charity care policies, collection policies. They're to be approved at the board of directors level, making sure that in exchange for these significant breaks, the hospitals do good, provide charity care to the poor, and make sure people can still get their treatment. It requires the hospitals to undertake periodic audits of both their internal and their external collection practices to make sure those practices are in accord with various detailed written standards of our agreement, and as well to make sure those practices are in accord with the hospital's own policies. The agreements also prohibit both internal and external third-party vendors from engaging in aggressive, harassing, abusive collection practices. And so really the intent of the agreements were, number one, to make sure that hospitals were using what I call kinder, gentler debt collection practices, recognizing that hospital bills are different than other kind of debt, and that people are often, if you're sick, you need treatment, and especially in troubling economic times, not everybody can pay for that treatment immediately. And then also the agreements require hospitals to charge the uninsured the same price that they charge to insurance companies for the same treatment. Up until the time of that agreement, hospitals were charging uninsured patients, 3-4 times more than insurance companies for the exact same treatment. And so you had this perversity where patients paid an artificially high sticker price if they had no insurance that nobody else paid. The government didn't pay it, insurers didn't pay it. I think that the agreement really reflects what are community standards in our state, and would frankly be good policy for Congress to look at for the whole country.
What was Accretive's responsibility as a for-profit company contracting with Fairview, a nonprofit hospital, to comply with this agreement? And do you believe that Accretive violated your agreements, the AG agreements with Fairview and
Yes, Chairman Franken, Accretive specifically contracted with Fairview that it would be in compliance with all aspects of our agreement. That was something that Fairview wrote into the agreement with Accretive, is you've got to honor and comply with the Attorney General agreement. As I've pointed out, Fairview engaged in a variety of audits and was repeatedly warning Accretive that they were in violation of the hospital agreement and that Fairview wasn't going to stand for that violation. In many, many ways, they violated the hospital agreement, and we've laid that out in a whole separate volume of our report.
Do you believe that Accretive's activities at Fairview created a culture conflict with the kind of quality-driven culture that we expect from health providers here in Minnesota?
Chairman Franken, I do. One of the things that became very apparent during the compliance review is that Fairview has good doctors, good nurses, people who are very compassionate and view their work as almost missionaries to take care of the sick and the infirm and the ill. A charitable hospital, and especially an emergency room, should be a sanctuary to take care of people at the worst time in their life. I think that's certainly the values that have been expressed by the care providers at Fairview. On the other hand, Accretive, as a for-profit, Wall Street, money-making company, it wanted to create a numbers-driven culture at Fairview. We have a document in our report that says that we want it to be numbers-driven. The problem, Senator, is that healthcare isn't about numbers. It's about patients. It's about the patients sitting behind me today who experienced very tough times in their life and had a collector visit them in the emergency room. And that created a collision in values, the culture of a nonprofit charitable institution on the one hand, and the culture of a very hyper-aggressive collection enterprise on the other.
It seems to me that hospitals are also in a tough situation. The cost of health care is increasing. Hospitals are being squeezed on the revenue side, and at the end of the day, they're operating on a very thin margin. Hospitals have to find a way to collect the money that's owed to them, and I'm sure you'd agree. And collecting payment from patients at the time they get care is one way to do it. A recent article in Forbes says, quote, "Increasing point-of-service collections has become a major weapon in the healthcare industry arsenal to bring bad debt under control." But the same article criticized your investigation into Accretive, saying that you were erroneously attacking an important billing practice. How would you respond to that criticism? Are you concerned with point-of-service practices generally, or is your concern with the way they were implemented in this particular case?
Chairman Franken, there is a time and a place for hospitals to collect money. There's a right way to do it and a wrong way to do it. What Accretive orchestrated at Fairview is the wrong way to do it. Hitting up patients in their bedside gurney in various stages of undress where they're hooked up to morphine drips or have feeding tubes shoved down their throats is not the time and the place to collect money. This is a time of medical distress. It's a time of trauma. Some of the patients who were hit up in the emergency room hadn't yet been on pain medication, and they were, as I mentioned, in so much pain they literally thought they were going to die. Other patients, on the other hand, were hooked up to morphine drips, and they were groggy, confused, disoriented, the way that this company orchestrated the collection campaign was not the time and the place to collect money. Other times, patients were stop listed early in the morning, before surgeries. They were told, don't eat, don't drink for 12 hours. They got up at 3 in the morning to leave their house, came to the hospital at 5 for very, very important surgeries, only to be surprised to be stop listed and told, we need your credit card right now before you move ahead, at a time that they were weak and frail and suffering and groggy. That is not the time and the place to collect money. We have not tried through this compliance report to draw all the boundaries for point-of-service collections, but I can tell you the kinds of activity that we've outlined I don't believe is consistent.
Okay. Attorney General Swanson, I believe that when patients' privacy is violated, everyone is harmed. If patients can't trust that their health information will remain private, they'll be less likely to tell their doctors what conditions they have and what medications they're taking. In volume 4 of your compliance report, you talk about the importance of privacy. You say that patients are less likely to be candid with their doctors if they think their information isn't private. What sort of protections are in place to protect patient's privacy, and are those protections adequate?
Chairman Franken, privacy is a bedrock principle of the doctor-patient relationship. 2,500 years ago, the Hippocratic Oath for doctors said, "That which I shall learn in the carrying out of my profession, I'll keep secret and never reveal." The idea being that patients need to know their information is kept sacrosanct, that it's going to be treated confidentially. I know that's been a concern of many of the patients who have come forward to our office, that they were concerned about their privacy. Chairman Franken, one of the things we've seen in our compliance report, we have a screenshot of the information about a particular patient who was on the laptop computer, and it lists her name and social security number on the laptop, whether she has any of 22 chronic medical conditions, including HIV, schizophrenia, bipolar disorder, whether she's depressed, what's her likelihood of future hospital treatment, is she frail. And another example in our report, we have a screenshot of the type of information that could be collected or accessed by the Kalamazoo, Michigan debt collectors of Accretive. And this particular screenshot is a fellow who was depressed and attempted suicide by cutting his wrist. You can only imagine what a debt collector can do with that type of information. Now, under HIPAA, there are certain privacy protections in place. One of those is that a hospital and a third-party vendor are supposed to have, in HIPAA parlance, what's called a business associate agreement, and that agreement is supposed to lay out what the protections will be and how data will be protected. As it turns out, Fairview had a business associate agreement with Accretive, only Accretive violated that business associate agreement. At North Memorial, as it turns out, there apparently was no business associate agreement in place at all. North Memorial entered into a contract with Accretive in March of 2011, and in October of 2011, I sent a letter to North Memorial saying, "Please produce to my office your business associate agreement with Accretive." In the few days afterward, there were a series of emails between North Memorial and Accretive basically concocting to create a business associate agreement and basically backdate it or retroactively date it for presentation to my office. Greg Kazarian, I think one of your next witnesses from Accretive, is on this particular email from the CFO of North Memorial. It's dated October 13, and it says, "Greg, we're sending you the BAA. Could you sign and return so we can include it with our AG response?" North Memorial and Accretive thereafter concocted a business associate agreement. It's dated March 21, or effective March 21 of 2011, and it was presented to my office as if they always had a business associate agreement. In fact, that agreement that was presented to my office was really signed in October of 2011.
Okay, that's this news. Do you have those documents?
Chairman, I do.
Okay. Okay. I would like to see those.
I would be happy to present them. I think it would be very troubling to the patients that their information is being shared without that type of written contract.
Well, thank you. I need to move on.
Sure.
Okay. Commissioner Rothman, we have debt collection laws for a reason to protect consumers. Can you explain why it's important that debt collectors register as such with your commission, why it is important that debt collectors disclose to customers that they are debt collectors and that they are calling to collect a debt?
Mr. Chair, it's vitally important. We have both requirements for the companies and the individuals to be licensed and registered by the individuals. It's important because we want to know who are the people that are authorized to do debt collection in Minnesota, and then therefore are also required to follow the law for what are prohibited practices. There have been other investigations that I've looked into in which debt collectors were either unlicensed, unregistered, or not eligible because of their prior history in terms of whether or not they're qualified. Meaning, for example, they cannot have certain criminal background history. And so these laws are meant to be a first line of defense against consumers generally, and then in particular in the context of medical profession, to also make sure that these are professionals and abiding by the laws of our state.
One of the issues presented in this case is whether the people who were collecting payments at at the hospitals and from the call center were, and I'm going to use the term of art, debt collectors or financial counselors. What do you make of this distinction, and why does it matter?
Let me speak to Minnesota law. Under our law, under Section 332, it defines what a collection agency is and what it means and who a person is that does debt collection. The collection agency means it includes any person engaged in the business of collection for others, any account, bill, or other indebtedness, except as hereinafter provided, which these exceptions don't apply here. It's a relatively broad definition. It's a little different than what the federal law defines as what a debt collection agency is. And a collector is somebody who acts under the authority of an agency to do those things. In Minnesota, Accretive Health did obtain and does have a license from the Department of Commerce to be a collection agency. Individuals who do debt collection activity under Minnesota law would therefore also need to be registered. And to the extent they were not, and if they were not, they would be serious and troubling violations of the law.
Okay, well, in the interest of time, I'd like to move on. I want to thank you, Attorney General Swanson and Commissioner Rothman. You're now excused. With the next panel, please come forward.
Thank you, Mr. Chair.
As they're being seated, I'd like to introduce our second panel of witnesses. Charles Moody is the chairman of the board and soon will serve as interim CEO of Fairview Health Services. He's also the former CEO of International Dairy Queen and recently became the owner of the Minnesota textiles firm, Faribault Woolen Mills Company. Mr. Moody began his career working at Edina-based Dairy Queen in 1987. Greg Kazarian has been Senior Vice President of Accretive Health since January of 2004. He previously served as Accretive's General Counsel. Prior to joining Accretive, Mr. Kazarian spent 16 years with the law firm of Peterson and Haupt, where he worked on issues related to employment, intellectual property, creditors' rights, dispute resolution, and outsourcing. Thank you for joining us, Mr. Moody and Mr. Kazarian. I know that it's not an easy thing to take time away from your schedules to participate in this hearing and to give testimony. I really do appreciate your time. Mr. Moody, please go ahead with your testimony.
Good morning, Chairman Franken. My name is Charles Moody, and I am the chair of the Fairview Health Services Board of Directors, and will serve as Fairview's interim Chief Executive Officer beginning August 1st, 2012. Thank you for inviting me to be here today with you. As you know, Fairview has had a long and strong reputation of providing exceptional health care to the communities we serve. Fairview's reputation is built on a long track record of quality care and contributions to the local community. The issues that have come to the fore recently have been challenging for our employees, physicians, and leaders. And most importantly, we know that these issues created challenges for some of our patients who do not feel that they were treated with respect and dignity. To those patients, I offer my personal apology and firm commitment on behalf of the entire Fairview organization to regain your trust. The Minnesota Attorney General's compliance review includes several examples from patients and employees of business practices that are not in keeping with Fairview's values and code of conduct. And while Fairview is not a defendant in any Attorney General lawsuit, I can assure you that we are cooperating with the Attorney General's office in order to reassure our patients that we are committed to compliance with all laws and regulations, and above all else, improving patient care. Fairview has taken action to remedy the issues that have been identified prior to the Attorney General's suit. Fairview terminated its work with Medical Financial Solutions, a part of Accretive Health, on January 6, 2012. because of their failure to comply with the State Attorney General's billing and collection agreement. In addition to terminating our agreements with Accretive Health, we also have initiated better approaches for escalating patient, employee, and physician concerns so that they receive prompt attention. We are reviewing and revising our training tools to ensure each patient interaction reflects Fairview's core values. We've stopped collecting past due balances and co-insurance payments in emergency departments, and we're reviewing emergency department and registration workflow processes. We also have reallocated resources to functions within Fairview that handle refund and credit balance processes to ensure prompt repayment of amounts due to patients. In short, we are shouldering our share of the responsibility and taking actions to address concerns for our patients, employees, and physicians. Fairview's first priority is and always will be the care for our patients. All of our employees, physicians, leaders, and even board members are dedicated to patient well-being. The Fairview team strives to deliver exceptional care at all times in a respectful manner and in compliance with the relevant laws and regulations. Moving forward, Fairview leadership and governance members are going to do a better job of listening and acting upon patient and staff concerns and recommendations. And as Fairview transitions to a new leadership, I can assure you that governance will now have our renewed commitment to carry this forward. Thank you for inviting me here today, and I welcome your questions.
Thank you for your testimony, Mr. Moody. Mr. Kazarian, thank you for being here. I will note that I asked Accretive CEO to participate in this hearing, but she was unable to do so. But I understand that you are the head of compliance for Accretive and probably are the best person to talk about these issues that we're discussing today. So I'm glad that you're here. Mr. Kazarian, thank you. Please go ahead with your testimony.
Thank you, Senator. Good morning. My name is Greg Kazarian, and I'm the Senior Vice President of Operations and the Corporate Responsibility Officer at Accretive Health. I came to Accretive Health in 2004 because I believed in the company's mission and its vision for helping patients and hospitals navigate the challenge of rapidly rising healthcare costs. I came to Accretive Health because I saw a tremendous opportunity to make improvements in a broken and struggling healthcare system. I'm 49 years old, and I have a wife and 3 children. Between us, we have 4 aging parents, 2 of whom live across my backyard. As a family, we've experienced all of the usual medical issues that families experience every day. I know firsthand how important high-quality, compassionate care is. And I know firsthand how important it is that patients understand what insurance and public assistance they're eligible for, as well as their own financial obligations for their medical care. There are 3 things I'd like to cover quickly in these opening remarks. First, I want to thank you, Senator. Thank you for inviting us to speak with you today, for the time your staff has spent with us discussing these important issues, for your willingness to listen, and for your efforts to have an open and honest discussion as to how healthcare can and should be improved. I thank you on behalf of myself as well as the 3,000 employees who work at Accretive Health. Approximately 150 of those employees live and work right here in Minnesota. These individuals work as nurses, financial counselors, and social workers. Over 50 of them have chosen to attend this hearing voluntarily on their own time today. Senator, it's important that the work of these trusted, dedicated colleagues be understood and appreciated. And that is something I'm going to try to achieve in our time today. Today I want to explain what we at Accretive Health do. I suspect that many people in this room had never heard of Accretive Health before the last few weeks. Unfortunately, we've been portrayed in a way that distorts and misrepresents our business and our work. True debt collection is less than 1% of what we do. The core of what we do every day, everywhere we work, is help hospitals find all available coverage for patients and ensure that insurance companies and government programs pay the hospitals the money they're owed for the care they provide. For example, We go to bat for patients who've been denied insurance coverage for pre-existing conditions, and we get those claims paid. We advocate for patients when their insurance company refuses coverage for conditions that are medically necessary, and we get those claims paid. We fight to get patients who qualify onto disability so that they can get coverage for the care they need. Over 95% of the revenue we secure for hospitals come from insurance companies or government payers. As part of our work, we also help hospitals collect the amounts due to them from patients. And we help the patients themselves understand the coverage they have and how it's going to respond to that episode of care and the benefits they may be eligible for. This is information patients want to know and need to understand. We're proud of the work we do, and particularly proud of the fact that we've helped more than 250,000 formerly uninsured people obtain coverage for their care. 16,000 of those people right here in Minnesota. 16,000 people who didn't know they had coverage for the care they were receiving were connected to that coverage so it would pay for their claims. And for those who cannot pay and for whom we cannot find another source of coverage, we assist hospitals in getting those patients charity care and other financial counseling, including discounts and payment plans. The work of our quality and total cost of care program is another point of great pride for us at Accretive Health. In this groundbreaking program, we help care providers identify and reach out to the sickest patients they serve and coordinate their care and services to provide it to them in ways that help improve their health care and reduce the need for costly emergency room visits. For example, by connecting social workers with homebound patients or patients who are vision impaired, we can create safer living environments that reduce accidents. For patients with insufficient social networks and those with memory problems, we coordinate transportation to pharmacies so those patients don't get sicker. I sincerely hope to have an opportunity to talk today in more detail about this very important part of our work. The final comment I would like to make is perhaps the most important. Accretive Health is a company that believes our mission is to help patients and strengthen the financial viability of the not-for-profit hospitals we serve. We take seriously the allegations that have been raised by the Attorney General and appreciate the opportunity to have this dialogue and set the record straight. As a company, we firmly believe that even one unsatisfied patient is one too many. Let me be clear. Many of the allegations we've heard this morning and in the press are deeply troubling. And if they are true, they would be flatly inconsistent with Accretive Health policies, our training, and our values. To any patient who experienced any interaction with us or with our Fairview colleagues that lacked compassion and professionalism, we sincerely apologize.
Thank you.
Again, we thank you, Senator, for inviting us to have this dialogue, and I look forward to your questions.
Thank you so much, both of you, Mr. Moody, Mr. Kazarian. Mr. Moody, I understand that you are in the process of transitioning to become Fairview's interim CEO, so that you may not know every detail of the day-to-day workings of the hospital or what happened. But as chairman of the board, I hope you can answer a few questions. And if there's something you need to check on, I hope that you'll follow up with me. Fairview has been around for over 100 years, right?
That's correct.
As far as you know, in those 100 years, has Fairview ever had problems like those that we're discussing today?
I think as the Attorney General referenced back in 2005 when the agreements were entered into before, that Fairview was part of the group that had had challenges and issues with the Attorney General at that time.
Okay, thank you. I was very disturbed by Mr. Moody, by the allegations that Accretive was badgering patients in Fairview's emergency room and in the neonatal intensive care unit to ask for prepayment and to collect on debts. What was your first reaction to these allegations?
I think all of us within Fairview love our culture and our commitment to our patients. And anytime both our patients and our employees are not in a comfortable situation, that's just very disconcerting.
If these allegations turn out to be true, would they violate any part of Accretive's contract with Fairview?
I'm not the legal expert to know exactly as to what the violations would do. My guess is that in many respects, if what has been reported is actual and truth, that would require an issue as it relates to any agreement or any activity with Accretive.
Okay, thank you. Mr. Moody, the Attorney General's report discusses what she calls a culture clash between Accretive and Fairview. She cites emails in which Fairview physicians expressed their discomfort with certain activities. Did Fairview perceive a culture clash between Fairview and Accretive? What steps did Fairview take to address these concerns at the time? And did Fairview staff address them directly with Accretive?
My understanding is that staff did elevate concerns to their appropriate managerial reports, and that was passed along. As to how high that was passed along is still something that we're needing to try to dive into and gain greater understanding of. But there's no doubt that there was a culture change and an uncomfortness that both went to our employee group as well as to our patients, and that's a troubling situation.
Mr. Moody, can you tell me what steps Fairview has taken to protect patients from inappropriate debt collections? How have Fairview's procedure changed since Fairview became aware of the Attorney General's investigation and the alleged activities of Accretive? And in Fairview's view, what is the responsible way, or the Minnesota way, if you will, to collect payment from patients?
I think the first and foremost is to make sure that whatever our procedures are, is that it's within the rules and laws of the state. And so in that respect, it's very vitally important that we uphold those laws as we go forward. As it relates to changes, we have now taken all of that collection in-house, and we have dedicated our team to new training and to new approaches and new scripting to make sure that we are upholding that as we go forward in time. I will do my darndest as far as what is needed to make sure that we steward this thing appropriately and guide it to a point where our patients feel that we are being both good stewards and managers of our resources, but also providing exceptional quality care.
Thank you. Mr. Kazarian, in its response to my letter, Accretive said that, quote, while the revenue cycle employees in the call center working to collect payments from patients typically refer to themselves as patient financial advisors or debt recovery specialists, these employees also may have from time to time identified themselves as financial counselors. Now, all these terms, patient financial advisor, debt recovery specialist, financial counselor, seem misleading to one degree or another. Shouldn't the people in the call center disclose at the outset that they are debt collectors calling to collect a debt?
Senator, there's two aspects of work in that call center, and I'm in full agreement with you with respect to those people who are collecting on age debt that is in default, which is the way the Fair Debt Collection Practice Act defines it. In healthcare billing,
maybe we should talk about changing.
Yeah, yeah. And we might. And I, you know, I've spent 7 years of my life in this company working on these issues that I talked about in my opening statements, and we are.
Well, how does Accretive determine when a debt is in default?
Actually, Accretive doesn't do that. The hospital policies will typically dictate that. In most instances, it'll be deemed in default at anywhere from 120 to 180 days after the date of statement of service. And the unique issue that you have, the reason we...
You're saying the hospital does it, but don't you, on all of revenue cycle issues, don't you control what the hospital does? That's what it says in your SEC filing.
No, Senator, that's not accurate. I can get to the reconciliation of the SEC filing if you'd like to, but what our contracts all provide is that we will operate in a manner consistent with the hospital's policies and procedures on all the areas that affect the services we provide. So if the hospital says that a debt is in default and to be referred for follow-up, that's what we adhere to.
Okay, it just seems like it's a legal technicality. Most people think of debt as money that they owe to be collected.
Yeah, I understand that, Senator, and that's why I'd like to talk a minute about an area where I think that there's more thought to be provided. In
Sure.
healthcare, we have this unique situation where the patient who's receiving the care, absent some dialogue with somebody, doesn't know what they're going to owe. So if you have, when my son went to the emergency room and then got his knee surgery, we didn't know what our deductible was, what our co-insurance share might be, and unless somebody sits down and talks to you about how Blue Cross is going to handle that care, what they're going to charge, you don't know.
I think I was talking more about the call centers.
Well, and so now, in the call center, there's a concept in healthcare called early out vendors or pre-collect. And what that's talking about is those financial advisors. These are people, if I send that balance and call a patient and say, you've been referred to debt collection, 30 days after receive the statement, then Fairview and hospitals all across Minnesota are going to get complaints that that's been escalated prematurely. Why did you send me for debt collection? I just had questions that I didn't understand the bill. So the reason the scripts and the language is different for earlier debt than later debt is because we recognize the first thing patients want to do, and I think your bill actually contemplates it, is understand that the amount that you think is due is an amount I understand, and once we agree on that, then we can talk about how to take care of it. So that's the reason for the different language around a call that's early, where the obligation might not be understood.
I understand. I mean, I was kind of referring to calls that were a little bit later in the cycle, but let me move on. Mr. Kazarian, in your letter to me, you say that revenue cycle employees, this is a quote, revenue cycle employees work to communicate with patients with the greatest possible compassion. Now, I have to say one of the most disturbing documents I've seen in this investigation is an email from an Accretive revenue cycle employee who describes patients as deadbeats and plebeians, and who said, and these are his words, that he, quote, really takes the approach of being stern and calling people out for being stupid, because if they keep hearing it, they may eventually realize their stupidity and possibly feel just a hint of guilt for being such a schmuck, end quote. And this is the part of the email that I can quote in an open hearing. Believe it or not, most of what he says in the email, or a lot of what he says in the email, is even worse. Now, obviously, what was written here doesn't square with anyone's notion of compassion. So I have several questions about this email. First, when and how did you become aware of this email?
We became aware of it in gathering documents that we'd been asked to gather in response to what was a collaborative dialogue we were trying to engage in with the Attorney General's office. She'd asked for us to voluntarily produce some documents, and we were in that process.
If you didn't really get it till then, what did Accretive do to make sure that its employees were following its policies about communicating with patients?
First, let me deal with one issue with respect to that email and that associate. That language, that attitude does not square with our values. It is not consistent with our values, and that employee was terminated within 24 hours of us discovering that email. So let me just, for everybody here, make it clear that is not who we are, and that's not what we do. What do we do to make sure and to detect somebody like that? We have all of our collectors, we do a quality scoring of 2 calls every day that we listen to, and not just for compliance with law, but for tone, for conduct, for professionalism. If an associate does not reflect our company's values, they will not work in our call center. That's how we listen for it, we troll for it. All of our calls are digitally recorded. a second feedback loop is that if there's ever a patient complaint, it may come to the hospital, it may come to the Better Business Bureau, from whatever, it may come from any source. If there's ever a patient complaint, we can listen to that call, it's digitally recorded, and we can determine whether or not they've acted with the care and compassion we expect.
So I take it that you would listen twice a day to this employee?
We'd listen twice a day to this employee. That tone and attitude hadn't been reflected. Then we took a step further, Senator, and after we discovered this email, I asked our internal audit team to listen to another large group of calls for that employee to make sure that terrible offensive attitude hadn't crept into his exchange with patients on the phone. With the idea that if there was anybody that I needed to affirmatively reach out to as an officer of our company, I wanted to do that.
Doesn't an email like this make you concerned about the culture in the call center? I mean, if an employee works in a setting where he thinks it's okay to send an email like this to his coworkers, doesn't that kind of mean you have a real problem on your hands?
It could, and we looked very closely at that issue. What I was somewhat comforted by was that the employee who received the email was, you could tell by the response, was taken aback and wasn't engaging. It wasn't as if this was an exchange. It was, in fact, you could see in the tone somebody who didn't want to engage in this exchange. We spend a lot of time at that call center. We have records we've shared with the Department of Commerce that indicate that patients that callers and collectors that don't reflect our values can no longer stay with our company. And we'll keep working at that every day. We listen to those calls and we believe in our people.
Mr. Kazarian, it seems like Accretive often tries to pass blame off to Fairview. For example, in your written testimony, you say that Accretive, quote, did not control Fairview or its employees, end quote. And you say similar things throughout your response to my letter, things that would lead most readers to believe that Accretive did not have full responsibility for Fairview's revenue cycle. But in reality, isn't it the case that Accretive did assume full responsibility for the management and cost of Fairview's cycle?
Senator,
revenue cycle.
Yeah, we work in our work in a partnership model. At the end of the day, both practically and contractually, if there is any disagreement with any aspect of the revenue cycle work, the final authority sits with Fairview. Now, having said that, I'm concerned if we've left you with that impression. We viewed our work with Fairview as collaborative. We saw it as a shared set of responsibilities. I think what we're trying to simply assure people is that in doing that practical work together every day, we are guided by Fairview's values. And if at any point in time there's an inconsistency between Fairview's value and a particular practice we might be recommending, Fairview's policy and Fairview's values will dictate what we do.
It just seems that time and time again, both in your written testimony and in your letter to me, that you kind of pass off responsibility to Fairview employees and that you don't take full responsibility for Fairview's revenue cycle. And that's concerning to me because Accretive has said in its SEC filings, in no uncertain terms, that Accretive, and I quote, assumes full responsibility for the management and cost of a customer's revenue cycle. Accretive says that it has, quote, the right to control and direct hospital staffs. It says that, quote, we directly manage our customers' employees engaged in revenue cycle activities, end quote. It even says you can fire the employees. It says this in your SEC filing. It seems to me that Accretive is saying one thing in the SEC filings that it does assume full responsibility, and that Accretive is saying pretty much the opposite thing in the documents that I got from you and in your written testimony today, that Fairview is responsible, and I just don't get it.
Senator Al, at Fairview, as I've said, Fairview wrote these partnership principles into our agreement. We honored them. We were happy to provide for them. There is language that says we have direct financial responsibility, and that is the case. It is the case that if the cost of providing revenue cycle services to Fairview rose beyond what they had been previously, Accretive Health was fully responsible for.
Well, it's not just for the, I'm sorry to interrupt you there. It says in the filings, assumes full responsibility for the management, not just the cost.
And the only way I can reconcile that, Senator, is the filings are written in a general template form. I mean, they speak to a broad array of agreements. We have 26 agreements that are carefully negotiated over a period of time, and different clients have different objectives in terms of how they want our revenue cycle services to be governed in their agreement. The best way I can reconcile what you read in our agreement with Fairview and what you read there is that it would seem to me the SEC filing is written more broadly, and that in the Fairview agreement, our specific relationship with respect to Fairview is set out there.
Okay, I would just remind you that the SEC filings are what investors, you're a public company, and the SEC filings are there for a reason, so that investors who are investing in Accretive can know what rules it's operating under. And they seem greatly at odds with what happened, with what you wrote to me in response to my questions when I asked, did Accretive employees do this? No, it was Fairview, et cetera, et cetera. So let's move on. In your letter to me, you say that financial counseling was optional for patients. I take that to mean that the patient could choose whether or not to have a conversation with a financial counselor. Is that right?
Correct.
But the scripts that Accretive gave employees to use when collecting payments make it look like those conversations were anything but optional. For example, one script teaches employees how to overcome objections from patients. So my question is, how are patients supposed to know that these conversations were optional if nobody indicated in any way that they were optional?
I don't know the specific scripting that you're referring to, and there's a lot of scripting to different scenarios. But what I would say to you is that at the top of every one of our scripts around patient care is a bold legend in red at Fairview that says not only are patients never to be denied service for non-payment, they're never to be given the impression that service would be denied for non-payment. The role of these conversations is to help patients find a way to resolve their contractual obligations, but more importantly, to educate them about these responsibilities. The information below is to be understood only in that context. So Senator, again, I said in my opening statement, we will strive to be better every day. But what we believed we communicate in our training is that balance of issues.
I understand that that disclaimer was there, or you say it was there. The scripts that I saw that were produced by the AG's office do not have any disclaimers to the patients. I mean, that there was no way that the patients were told that the conversation was optional in the scripts. So how do you explain that? I mean, in other words, it's one thing to put something instructing, in red, bold, okay, this is our policy, but then to give them a script that doesn't have a disclaimer saying, by the way, you don't have to have this conversation with me right now. It seems, how does the patient supposed to know this requirement, which is that they know that this is an optional conversation?
Senator, I think the patient should affirmatively be given that information, and I will look at our scripting, and I will make sure that that affirmative language is explicit in multiple ways across the scripting. I take your point, which is that it is important. It is the absolute intent that these conversations are had at a time when patients are ready to receive them, and if we can make our scripts better, then we'll get at that work tomorrow.
Okay, thank you very much. Mr. Kazarian, I'm concerned that Accretive's employees had access to more protected health information than they needed in order to perform their duties. In Accretive's response to my letter, Accretive says that it developed a software tool to restrict its employees' access to just a handful of data points. These included things like the patient's name and contact information, the person financially responsible for the patient's care, the date of service, and a general description of the diagnosis code. It seems to me that that would be all that Accretive employees would need in order to collect debts or do that part of the job. But Accretive's response to my letter says that Accretive did not even begin to implement this software until 8 months into the contract with Fairview, that the tool was not even operational until February of 2011, which is about a year into the contract, and even that some revenue cycle employees continue to have access to Fairview's complete patient files for a full year after that. Now that begs 4 questions. First, why did Accretive wait until 8 months into its contract to begin limiting its employees' access to protected health information?
That's perhaps a bit of a misperception. We had a comprehensive plan to assure that patients working with Fairview only had that access to that health information minimally necessary to do their job. I believe that the portion of our response you're referring to relates to activities in the Kalamazoo Collection Center. The Kalamazoo Collection Center didn't start serving Fairview patients until I believe August or September of 2010. So that was part of the lag. And then you had a mechanism, you had to decide how you were going to have people access that information. Because the legacy system, I think it was called PAS, at Fairview didn't allow for the parsing of data as precisely as we would have wanted, we had to build a custom, if you will, frame to receive that information. So that's the, without getting too into the weeds about the technology of it, Senator, that's my understanding of that sequence.
Well then, why did some revenue cycle employees continue to have full access to patients' protected health information even after the restrictions were put in place?
Yeah, so I'll bifurcate in that answer between people who were doing the work at Fairview on the claim denial and follow-up work, those people that were trying to overturn the denials on pre-existing conditions, those people who were trying to overturn the denials from a payer who said that the procedure lacked medical necessity. I think it's clear that those individuals doing that work have a necessary reason for access to health information because they use it to advocate to get the claim paid. So that's one group of people that had that access authorized by Fairview, and I don't think there's any disagreement that that particular access was appropriate. In the call center, the approach that was taken was that patients who were calling and wanted more information about their, I don't believe this charge, or I wasn't at the facility on that day, or I thought it was already paid. There's 2 ways to approach that. One is to push the patient back to the hospital. I'm sorry, you'll have to follow up directly with the hospital. Working with Fairview, we made the judgment that it would be appropriate to have 2 or 3 managers in the Kalamazoo call center with discrete access so that they could handle that escalated patient question and be more responsive. You've asked about things we can think about in the future, and there's an open question as to whether having that escalation, that information necessary to handle that patient query is appropriate. It's permitted today, and that's the discrete purpose for which that would have been used.
Okay, it doesn't seem like it's actually necessary. If all that they're disputing is when the procedure was done and what it was, that is the discrete information, the minimum necessary information that anyone would need. And I don't understand why they need access to all their health care information prior to that. I don't quite understand the response, but related to that, I mean, do you believe that Accretive complied with HIPAA's minimum necessary requirement, which says that covered entities have to restrict their employees' access to protected health information to only that which is needed for the employees to perform their job?
Yes, Senator, I do. We had very clear procedures and authorization mechanisms to make sure that if our patients were being provided access to patient health information, it was that amount minimally necessary to do their work.
Okay. Matthew Doyle was a revenue cycle employee. An unencrypted laptop containing sensitive information about 23,000 Minnesota patients was stolen from his car. And I don't understand why Mr. Doyle had all that information. The law says that Accretive may give its employees, and you just said it does, only the minimum amount of data necessary for them to do their jobs. Why did Mr. Doyle, a revenue cycle employee, have all these data?
So there were two discrete sets of information that Mr. Doyle had at the time that his laptop was stolen from his vehicle. The first was the information relative to the work he was doing in claim follow-up, disability applications and processing, and the nature of that work in revenue cycle. The other, there was a discrete data file that he had in connection with his work coming up to speed in our area and in our work in the quality and total cost of care.
He didn't work in that, though, did he?
No, he did not, sir.
So he would only need that information if he did work in that. I mean, he was in revenue cycle, and you said that you, in your letter back to me on my questions, you said that you gave him that material because he was interested in learning about the QTCC model that you do, but he wasn't an employee for QTCC. I mean, he wasn't, it's not a, knowing this information isn't required unless you actually have that job. And here, this information was left in a laptop in plain view, and there was a smash and grab, as you refer to it, or as it's been referred to, at 7 Corners. He was not a QTCC employee, he was a revenue cycle employee. Okay. Let me move on to the next question. Accretive says it has a policy of encrypting all laptops. And that seems like a common sense policy to me. Right now, the law does not expressly require encryption of all portable protected health information. That is, all protected health information that is contained on laptops and other portable media that are vulnerable to theft, as you had 9 in 2011 laptops stolen. Do you think the law should be updated to require that practice? It is, after all, practice that Accretive says it has in place now.
Yeah, I think that's it's an appropriate change to consider. I would tell you that one of the things that drives people in the healthcare services arena to that standard is that when you apply encryption and you do it, you fit within the safe harbor of the High-Tech Act under HIPAA. And so I'll leave it to you and your colleagues to decide whether it sits better sort of with that regulatory incentive rather than as a matter of law. But one way or another, it is an important standard to drive anybody that's receiving this information to.
Well, thank you, Mr. Kazarian. Should I continue? Yes. Okay, we have enough time. I'm just checking on the time. Mr. Kazarian, the Attorney General alleges that patients were charged for the predicted patient share of a service, but that these predictions sometimes were inaccurate. The Attorney General also alleges that Accretive delayed refunding overpayments. In one of the exhibits, I saw an excerpt from a registration handbook. Accretive instructs employees not to notify patients when they're talking to them that they have a credit on their account. Instead, it tells them to say nothing about the credit. Why would Accretive instruct financial counselors not to let the patients know if they had credits on their accounts?
Two answers to that, Senator. First, what ought to be happening is that any patient balance, any patient refund that's due, ought to be remitted and transferred in a check within 30 days of its determination. So the process ought to be that if there's any patient refund due to a patient, that patient ought to receive that patient refund within 30 days. The reason you would do, the reason you wouldn't engage in that in the time of service is because you'd have to coordinate those two processes, and there are times when that identification of a possible balance isn't an actual balance, and so we'd be passing paper back and forth. We found if you focus your energy on getting payments, refunds that are due, and putting that check in the mail, it's the most straightforward way to make sure that the patient knows you refunded that particular amount without the confusion in an already confusing environment.
If they hadn't received a refund after 30 days, would you then tell them?
That's a, let me take a minute to think about that.
Well, I'm afraid you're going to have to think about that a little later, because we've run out of time for this panel, but I want to thank you, Mr. Kazarian and Mr. Moody, for your testimony and for coming today and answering questions. Thank you very much. I now call the next panel. Thank you.
Thank you for your interest.
Thank you, gentlemen. Oh, I'm good. I got enough. Well, I might. But don't give me the physical. Now I'd like to introduce our third panel of witnesses, Tom Fuller from New Brighton and Deb Walden from Edina. Both Mr. Fuller and Ms. Walden are former Fairview patients. Ms. Walden and Mr. Fuller, thank you so much for participating in this hearing and for sharing your stories. I know that is not necessarily an easy thing to do. My main goal here is to figure out whether existing law is adequate to protect Minnesotans like you when you go to the hospital. I also have a lot of questions about the evidence. That's why I asked Accretive and Fairview and the Attorney General so many questions about the exhibits, the reports, and the legal filings. But look, it's really important that we not lose sight of the human element of this. So I'd like to hear about your experiences with Accretive and Fairview. So I'd just like to ask you some questions, and Ms. Walden, I'll start with you. I understand that you visited Fairview's emergency room in July of 2011. Why did you go to the emergency room that day?
That evening I started...
Can you talk a little closer to the mic, I think?
Sorry, I'm new at this. I started experiencing some pain in my side that within an hour just went off the charts with pain. So I had a friend take me to the emergency room at Fairview Southdale. She dropped me off, and I stood in line waiting for triage. I was in so much pain that I barged to the front of the line and said, I need help here. I need some help right now. And he got a wheelchair. He put me in a wheelchair to the side, and I waited there for maybe 10 minutes. And then someone came and took me into the room in the ER. I was put on a gurney. By that time, I was just with debilitating pain. I was in a little ball in a fetal position, wishing I could die. This ultimately ended up being a kidney stone, which if anyone's experienced that, terrible pain.
Well, you say you're in pain.
Yeah.
Doctors sometimes use a scale of 1 to 10. On the scale of 1 to 10, what you were experiencing.
I wouldn't be exaggerating if I said a 12.
Okay.
It was bad. And
Now, had you been given any pain medications, anything
No.
to relieve the pain before you were
No.
approached by a billing employee?
No. They started me on a morphine drip afterwards, but I had not seen a doctor yet or had any kind of pain meds.
So, okay, so you're writhing in pain on the gurney, and you're approached by a financial counselor. Was anyone with you when you were asked for payment, or were you alone?
No, I was alone.
Okay. How did you feel when the man came to your cot and asked for the payment? Did you feel vulnerable? Did you feel scared? How did you feel?
Yeah, I saw out of the corner of my eye, I saw this little guy wheeling a podium with maybe a computer or something on it. I wasn't sure. And I was just having such pain, it was hard to process what he was saying, but I do recall he said I needed to pay him between $700 and $800. And I think it was like $750 or something. And I couldn't believe he was asking me this at the foot of my bed as I'm laying there. And I said, I have insurance. I don't know what you're talking about. And to be clear, I didn't have any debt with Fairview. I didn't owe them any money. I had no debt with them. And he was asking for this money right then as I'm laying there, and I just ultimately told him to get out of the room and go away, and he did.
Okay, now, as best you can recall, understanding you were in a great deal of pain, had you been seen by a doctor at that point?
I don't believe I had been.
Okay.
It seemed like a long time that I was waiting for a doctor, but a long time when you're in that kind of pain can maybe not be that long, I'm not sure.
Okay, now, did you have medical insurance?
Absolutely, yes.
Would you have paid your bill even if you had not been approached
No, I did
in this
pay my-
vulnerable state?
I did pay my bill, yes.
In fact, okay, you did pay it when you were back
Yes.
at
yes,
home.
Yes.
Do you think there's a better way to collect payment from patients than the way you were treated in the hospital? In other words, do you think trying to collect from patients while they're in pain in the emergency room is a bad policy?
Yes, I think it's a very bad policy.
Did you complain to anybody about the way you were treated?
Yes, I did. I called a couple days later. I called Fairview and talked to maybe some patient representative. I'm not sure who it was. And she didn't really have an answer for me. It sounded like she didn't know what I was saying almost. And I didn't get nothing happened from that. She just kind of poo-pooed it. And then Fairview sends out a survey, at least to me, maybe a week or two later, to fill out your experience. And without a doubt, the doctors and nurses were fabulous, and I want to make that really clear, that they were wonderful to me.
I'm sorry, so you were satisfied with the care that you got from the
absolutely.
doctors and nurses?
Once I got that, absolutely. But I did write on that survey that this man had come in and approached me under my circumstances that I thought was just terrible.
I think that is very important, that you're very satisfied with the doctors and
Absolutely.
nurses at Fairview.
I think they're getting a bad rap, the whole Fairview is, and the doctors and nurses were great.
Thank you. Thank you very much, Ms. Walden. Mr. Fuller, I'd like to ask you similar questions. Can you tell us about what happened when you visited Fairview Hospital in November of 2011?
Well, I had been going to the hospital there for 3 years, never any problems. Lung transplant.
Maybe put the mic a little closer to you so we can all hear.
I had a lung transplant in January of 2011, and I had many complications throughout the year. So when I went in for this procedure in November of 2011, I still really wasn't totally with it. And my wife had been taking care of all the financial ends of it, and she was there every time I was at the hospital. On that day, I checked in at the front desk, and they always do all the check-in right there, put the little bracelet on your wrist and sign the waiver. But this particular time, the person at the front desk said that so-and-so will be checking you in. I thought it awful weird because for 3 years, nothing like that had ever happened. And as I was being held, guided back down a hallway, my wife got up to join me, as she always has, and the nurse says, no, you'll be okay, you don't need to be in there. And they took me into a small little office, about 10 square feet it seemed like. The gentleman checked me in, as usual, printed off some papers, signed the waiver forms that are protocol, and then the last thing he did is he put another piece of paper in front of me, which was a bill for $500 and some. And I said, what's this? And he said, well, we need to pay up on your outstanding balance. And I said, outstanding balance? I said, we paid over $10,000 in this year, and we had gotten a bill the past week, and our balance due was $380. And we were unaware of any past due amount, and I just felt badgered, and it just got extremely upset. Finally, he said, well, I'll take a check or a credit card, however you want to pay it. And I said, I have no intention of paying you anything right now. I'm going in for a procedure. So he put, on the bill, he put Accretive's name, number, and another name for a person to talk to. I went out of the room, and everybody in that waiting room knew what happened in that room. I was shaking, I was furious. Just nobody at that point should be going through that. And my wife, she called the guy in the paper, and they got home, and she called him back, and they went through it, and he kind of agreed that one of the charges on there wasn't correct. But finished my procedure and went home.
Now, you had undergone a lung transplant.
Lung transplant, yes.
So you were vulnerable. I mean, you were weak at this point, right?
I had many side reactions all year long from the medications.
And I understand you, they knew about your condition, obviously, from your medical records. So they should have been aware that you were in a compromised state. I understand you had visited Fairway many times before. About how many times?
Starting October of 2008, I can't probably, leading up to the transplant, I bet you 50, 60 times a year.
Had anyone ever demanded that you provide a credit card to pay a bill when you came for a scheduled procedure before this visit? No.
We stayed, we had payment plans, and we stayed on top of it. We were never late with the payment. We made a payment plan of a certain amount that in a bad month, if we couldn't pay the whole bill off, we had a cushion to go back on, but we paid the bills every month. And to our knowledge, we were satisfied. We only owed $380.
Now, I understand you had asked for your wife to come with you. Why was that?
Because of the state of mind of where I was at the whole year, I needed a second set of ears with me. at most times.
So,
And they said that she didn't need to come in.
okay. So how did you feel during this? When you were taken to this back room and pressed for a payment, did you feel like you were being shaken down?
I was outraged. I was shaking. I was just totally upset.
Did you feel like the conversation with the financial counselor was optional? In other words, did he tell you that you didn't have to have that conversation?
No. I was told to come back to this back room, and he went through the normal spiel of checking in, and without losing a breath, he put the bill down and started asking me for money.
Setting aside your experience with debt collections, how was your experience with Fairview? Were you satisfied with the care that you received from the nurses and from the doctors?
I can't express enough the care that I received there. Doctors, nurses, coordinators, food service people, housekeeping. I spent many weeks off and on in the hospital, and no, that's what really bothers me, because it's a great facility. The people there are fantastic, caring, and the people that I had to talk to you, like on the phone, you knew they didn't want to be saying what they were saying.
How are you doing now? How are you feeling? I mean, a lung transplant, I can't imagine. That'd be like you were going in for a trach, replacement of a trach tube or something like that day?
No, it was a feeding tube.
A feeding tube, I'm sorry, a feeding tube, of course.
Have not traded out.
Yeah.
I'm
How you doing?
doing better.
Good. Well, thank you both very much, Mr. Fuller, Ms. Walden. Thank you for being here today and being willing to testify. You're now excused.
Thank you, Senator.
Okay, would the last panel come forward, please? I'd like to introduce our fourth and last panel of witnesses. Jean Ross has been a registered bedside nurse for nearly 40 years and is a member of the Minnesota Nurses Association. She was a nurse at Fairview Health Services and now is co-president of National Nurses United. Michelle Goodwin is the Everett Fraser Professor in Law at the University of Minnesota and holds joint appointments at the University of Minnesota Medical School and the University of Minnesota School of Public Health. Professor Goodwin is a prolific scholar who focuses on the role of law in the promotion and regulation of medicine, science, and biotechnology. And finally, Jessica Curtis is the Director of Community Catalyst's Hospital Accountability Project, where she advises consumer advocates and policymakers on hospital financial assistance and community benefits programs. Prior to joining Community Catalyst, Ms. Curtis provided legal services to low-income elders at Boston College's Legal Assistance Bureau. Thank you, Ms. Ross, Professor Goodwin, and Ms. Curtis for joining us. Ms. Ross, please go ahead with your testimony, and please do keep it to 5 minutes. Thank you.
Senator Franken, thank you for holding this important hearing on behalf of patients, family members, and nurses at Fairview and all over the country. My name is Jean Ross, and I am a registered nurse. In December of 2009, I was elected co-president of National Nurses United and currently still hold this position. Previously, I worked as an RN for Fairview Southdale Hospital in Edina, Minnesota, for over 35 years. The following is my personal account of 2 different incidents involving the Fairview healthcare system in the past 2 years that affected my family and me. In 2010, my infant grandchild was very ill over one weekend. On a Friday and then again on Saturday night, I accompanied my daughter and the baby for separate trips to the emergency room. This was at Fairview Ridges Hospital in Burnsville, where he was eventually diagnosed with encephalitis or meningitis and was then transferred to Minneapolis Children's Hospital. Our time at Ridges was made especially jarring, however, by the actions of some ancillary personnel who had nothing to do with the care of our young family member. My daughter was extremely worried. She had many questions, but she was holding up pretty well until I left to use the restroom. When I returned, she was holding the baby and sobbing. I assumed she must have received some very bad news about the baby's condition. Instead, I learned that while I, the nurse, and doctor were out of the room, a woman had come in and asked if my daughter was willing to pay all or any part of her bill now. My daughter told her no, she could not. As background, my daughter and her husband are among many families hit hard with medical bills and changes to insurance coverage. She certainly did not need reminders of her financial position while under the stress of worrying about the condition of her youngest child. Now fast forward to February of this year, my same daughter's just delivered her third child at Fairview Ridges. Within 24 hours, a Fairview representative visits in her room with the goal to extract some or all of the payment for the bill. According to my daughter, this woman at least was apologetic. She even confessed, "This is the least favorite part of my job." Senator Franken, I spent much of my time at Fairview Southdale working in the ER. While there, I witnessed no such behavior. This kind of, I call it ruthless corporate behavior, just wouldn't have been allowed. A nurse's main focus is to advocate for patients and families. We urge patients to put other worries aside and to concentrate exclusively on healing. They certainly don't need the added burden of being pressed for payment while they're being treated. Every nurse wants to be proud of the work we do. We expect policies that allow us to do our job properly. We want to be able to speak well of the place that employs us. Programs or policies that encourage or require bill collection while a patient's being treated are, I believe, unethical and don't belong in any healthcare setting. It does not reflect well on any institution, and I'm very disappointed in the system that employed me for so many years. I'm even more aggravated at an overall healthcare system that doesn't allow universal access to all who are vulnerable, and which drives providers to this misguided and disgraceful behavior. This is exactly why our trusted and proven system of Medicare should be expanded so every man, woman, and child could be included in Medicare for all. I thank you for your time.
Thank you very much. We'll handle that last part in a different hearing, I think.
Just a hint.
Professor Goodwin, your testimony, please.
My testimony today covers two components. Hopefully we'll get to the second. The first is to explain why, as a matter of law and policy, that members of Congress should be concerned about contemporary debt collection practices at some U.S. hospitals. And the second is to share with you a set of recommendations that can help move forward your inquiry beyond investigation, the investigation stage, to exploring meaningful options to improve patient access to health care, reduce, if not eliminate, nefarious collection practices, and shore up a commitment to patient privacy. And I do commend you, Senator Franken, for chairing this hearing and to moving forward in your efforts regarding consumer protection against overreaching debt collection practices. The allegations outlined by Ms. Swanson's office are worthy of your sustained attention because they outline a disconcerting pattern of coercion, exploitation, fraud, near extortion, quid pro quo emergency medicine, indifference to patient privacy, and abuse of patients. These activities were allegedly carried out under contractual relationships that incentivized such conduct. These types of practices are not protected by law. Indeed, these practices are an egregious disregard of laws championed by Congress. Specifically, the Emergency Medical Treatment and Active Labor Act, EMTALA, the Fair Debt Collection Practices Act, the FDCPA, and the Health Insurance and Portability Accountability Act, otherwise known as HIPAA, are intended to protect patients when they are at their most vulnerable. These laws are intended to ensure patient privacy, access to medicine during emergencies, as well as to provide not a mild but a very strong check against fraudulent, overreaching, and duress-inducing debt collection practices. The FDCPA was enacted in 1978 specifically to guard against the type of activities that have been described today. When Congress enacted this law, the following was noted in Section 802. There is an abundant evidence of the use of abusive, deceptive, and unfair debt collection practices by many debt collectors. Abusive debt collection practices contribute to a number of personal bankruptcies, to marital instability, to the loss of jobs, and to invasion of individual privacy. Nearly 35 years later, this law is treated as a relic rather than a living, robust feature of our nation's promise to its consumers. The FDCPA specifically prohibits the types of practices that have been alleged by the Attorney General's office. If the findings are correct from the Attorney General's office, we have a very clear violation of federal law. I'll point you to Section 805 of the FDCPA. In subsection A, it states that subsection prohibits collection agents from communicating with any consumer at, quote, any unusual time or place known of which should be known to be inconvenient to the consumer. Certainly, emergency rooms with people with feeding tubes in and the other kinds of situations that we've heard about today are certainly inconvenient and not the appropriate time or place. My submitted testimony goes further. I would point you to the emergency, to the EMTALA. The Minnesota Attorney General's report outlined a range of nefarious practices, including hospitals embedding debt collectors among their staff, including in emergency rooms. If this is true, hospitals deploying such tactics may have violated EMTALA if the practices resulted in turning away patients in need of emergency care. To explain, in 1986, Congress enacted EMTALA to ensure public access to emergency services regardless of the ability to pay. What we know is that the legacy that preceded EMTALA was one that was really quite a scar on our nation's history. It included turning away pregnant women who gave birth on the side of roads. Sometimes people died. We know that there has been a history in this country where African Americans have literally died on the steps of hospitals. I would just simply close with also pointing out to you that what we've heard today, and certainly what has come through in your line of questioning, shows a clear disregard for HIPAA as well and patient privacy, being located on laptops that have been stolen and that were not to be privy to individuals who had clearly more patient information than they needed for their debt collection practices. I have recommendations that are submitted as part of the written testimony.
Yeah, all the written testimony is part of the record. Thank you, Professor Goodwin. Now, Ms. Curtis.
Good morning, Senator Franken. I'm grateful for the opportunity to testify today. My name is Jessica Curtis, and I direct the Hospital Accountability Project at Community Catalyst. We're a national nonprofit consumer advocacy organization that focuses on health issues. The project works with hospitals, community groups, and policymakers to improve access to care and protect patients to the greatest extent possible from medical debt arising from hospital bills. We track public policies and have developed standards and model legislation that hospitals and policymakers alike can use to make billing and collections fair for patients. I think it's worth noting that in 2011, 1 in 5 people in the United States reported that their family had difficulty paying a medical bill, and 1 in 10 reported having a medical bill they could not pay at all. Insurance coverage alone is no protection against medical debt. About 76% of those with medical debt reporting having had health insurance when they acquired it. Today, I hope to provide some context by looking at what makes medical debt unique, the role hospital billing and collections policies have played in its proliferation, and what can be done to address these problems. First, medical debt can be distinguished from other types of consumer debt. As many have noted, with very few exceptions, patients attempting to access healthcare services do so out of medical necessity. Illness and injury are unpredictable and involuntary, and the stakes for patients are very high. Delaying care could result in disability or even death. A patient seeking care in a hospital's emergency room is in no position to bargain for a better deal, and in that sense starts from a very different place than a person walking into a big box store to purchase a flat screen television. Even with perfectly transparent prices, which we do not have in healthcare today, patients do not know in advance what their diagnosis and treatment options will be, or whether complications, which are not always preventable, will occur. The long-term effects of medical debt can be devastating. Over 60% of all bankruptcies can be traced back to medical debt or illness. Others have linked medical crises to home foreclosures. As family finances shrink, low and middle income families resort to using credit cards to pay down medical bills, but this strategy leaves them susceptible to high interest rates and lowered credit scores. And medical debt has been shown to have a chilling effect on patients' willingness or perceived ability to seek care in a timely way. To keep costs down, the uninsured and underinsured forego care more frequently than people with better coverage. So how do hospital billing and collections policies contribute to medical debt? First, we have to recognize there are good public policy reasons to look to hospitals to promote care. Their mission, tax status, public subsidies, social and corporate responsibility. And quite simply, for America's 50 million uninsured, hospital charges are simply out of reach. But too often, hospitals have been cited for aggressive billing and collection strategies, like failing to screen or notify patients about public programs or their own financial assistance policies before using more aggressive tactics to collect. Deciding to offer financial assistance or payment plans based on a patient's propensity to pay rather than their ability to pay. Using credit scores to determine a patient's access to lines of credit, placing liens on patient homes or garnishing wages, and overcharging the and underinsured for care. These complaints are common, the impact is devastating, and quite frankly, we have been here before. In the early 2000s, backlash against aggressive collection tactics prompted hospital groups to issue voluntary billing and collection standards. Clearly, more is needed to protect patients from hospital bills they simply cannot pay. So we recommend a three-pronged strategy that I'll just quickly cover. The first is we need to clarify the rules that hospitals have on billing and collection. And right now, there's a ready-made tool to protect patients as far as nonprofit hospitals go. Section 9007 of the Affordable Care Act put limitations on what hospitals can do to collect on patient bills and the timing with which they have to inform patients about these options. Second, we need to expand coverage to care. And third, I do believe that we need to expand the debt collection protections that are available to patients. Thank you.
Thank you, Ms. Curtis. Ms. Ross, thank you so much for your testimony. As an emergency room nurse with decades of experience, what do you believe is the most important role of a nurse?
Our main role is, always has been, to advocate for the patients. And that's what I find so disturbing, aside from the fact that it interferes with the patient's care. The nurse is the person that's coordinating your care when you're a patient. And I have had dietary people, if a curtain is pulled, ask, is it okay to go in a room now and talk to that patient? That's not even in the emergency room, that's up on the unit. I have had people from medical records or the triage area in the emergency room. Let's say someone had to be rushed back because they were having trouble breathing or having chest pain. Even those people need that information. It might just be a phone number, an address, etc. But they know enough to ask me or the doctor, is this an okay time now? Is that patient stable enough? To have a stranger come in without my knowledge as coordinating that patient's care or the doctor's is not just an interference, it's unethical.
Nurses are often the providers who spend the most time with the patients in the hospital. I think they almost always are. And in national polls, nursing often is rated as one of the most trusted professions. As their nurse, would you allow patients to be badgered for payment?
I would not. I think it's unconscionable. This is not the time or the place. And, you know, well, as I said earlier, I can appreciate that they have to collect monies in order to do what they do. Sure. But this is not the time or place. And over all the years that I worked at Fairview facility, this just was not done.
When you say it's not the place, you're saying the emergency room.
No, I'm not just saying the emergency room. I think any point of care, when you're hospitalized, you do not need that extra burden, that stressor. It shoots your cortisol level way up. We don't need that. That's not part of healing.
Ms. Ross, the Attorney General's report says that maintaining the privacy of patients' health information is critical.
Yes.
Because otherwise patients would not have candid conversations with healthcare providers. Did you find that to be the case in your years as a nurse, what could go wrong if you don't have all the information
If I don't have all the information,
and the doctors don't have all the proper?
Well, obviously a patient is a complex human being. You need all that information. I am a little disturbed, and I noticed this too when I started reading the consent for treatment forms, because I read them for my parents who are elderly now too. And I did notice that over the years, the Fairview consent for treatment form had changed. And when I was last in with my father, I asked who this third party might be that needed this excess information. I'm used to, obviously you give it to other physicians, other people who handle your care, and to insurance companies who would have to process your bill. But I asked, who is this third party? And I was told those poor people at the desk, they don't know. What the lady said to me was, quite frankly, ma'am, nobody's ever asked that question, and if you don't want to sign okay to this, you just put your initials there and say no. So we did say no. But it came, obviously, after I started reading about what's going on here, I believe that's the third party they're talking about. And I do not understand why that pertinent medical information needs to be given to a third entity.
And if people don't trust that their information is going to be secure, they'll be less likely to give out personal information.
Exactly.
That you, as a nurse, and the doctors may need to know what medications that person's on, what conditions they have, so
Exactly.
that you don't prescribe, the doctor doesn't prescribe medicine that
Right.
will interact badly with other.
Exactly.
Ms. Curtis, in your written testimony, you explained that medical debt is different, and just now, from other types of debt, that people don't typically choose to rack up medical debt, and they definitely don't choose to get sick. Can you talk more about the special nature of medical debt and how devastating it can be for a family to deal with debt collectors while they're trying to heal?
Sure, and I can say probably the best way to talk about this is to talk about some of the patients that we've come across in our work across the country. Just to bring it to light, I think really what's happening is that patients are being forced to choose between their family's financial future and their health. And that's a choice that I don't think people should have to make, but frequently they do. So one of the patients that we have worked with, for example, in Florida, this was a woman who went into the emergency room for care. She was asked to take care of her bill at the moment. When she said she wasn't able to, she was asked if she had a credit card. So because she wanted to seek care, she put the bill on her credit card. The charge was $4,000. And it took care of her immediate problem. She was able to see the doctor. She was able to get treatment. But as a result of having that bill on the credit card, she ended up falling behind on her mortgage and is now in a very different situation where her financial health is in danger as well. Another story that I know has made the news recently in New York was a woman, a graphic designer, who for most of her life had been insured and employed but was hit hard by the recession. She went into one of New York's premier nonprofit hospitals and was asked immediately to pay upfront for care. She had, I think, a benign tumor on her liver. She did that. She raided her savings account and paid $17,000 right away. What ended up happening to her, however, was, of course, that didn't take care of the entire charge. And so she was landed with an $88,000 bill. She tried to work out a payment plan, was unable to do so, and ended up in court with the hospital. There, a judge recommended that the hospital accept her offer to make a $100 per month payment plan. And she has said she'll be paying that bill for the rest of her life. And again, you know, this is a woman in these situations, when people hear these stories, they're carrying that information and that knowledge with them the next time that they or their family requires additional help.
How do you think our federal debt collection laws should reflect the special circumstances around medical debt?
Well, one of the things that my organization has been working on is to really back up from the point where a debt becomes bad debt and we're in the position where people are collecting. Hospitals, to my knowledge, are mostly exempted from the Federal Debt Collection Protection Act. They are a creditor and they're allowed to do a lot in order to collect on their own debt. And again, we recognize that hospitals need to receive payment for services rendered. but we have become increasingly aware of and troubled by the same kinds of practices that we've heard alleged here in the Fairview and Accretive Health cases happening in hospitals across the country. And what's troubling is that the protection that's now in the Affordable Care Act and applies to nonprofit hospitals just applies to those hospitals. It's still very much predicated on what the hospital's own financial assistance policy is, and all of the protections in it, which would require hospitals to limit what they charge patients for care, and the steps that they take to screen a patient for before they engage in extraordinary collection actions. Again, all of those depend on their own financial assistance policy, and that's up to their discretion. So what we have is a situation where some hospitals have higher burdens placed on them, new higher burdens placed on them to be thoughtful about how they collect on bills. But not all hospitals in the United States have that. And then again, those protections differ as you move down the line and the account proceeds forward to become past due.
Thank you, Professor Goodwin and Ms. Curtis. As you both know, and as we've heard in our testimony today, tax-exempt or charity hospitals in Minnesota don't pay federal or state income taxes, property taxes, or sales taxes, and they can sell tax-exempt bonds. These benefits are worth billions of dollars nationally. In return, tax-exempt hospitals are required to provide a benefit to the community. Could that create a conflict of interest and potentially undermine the mission of a charitable hospital when it contracts out its revenue cycle management services to a for-profit and publicly traded firm? It seems to me that nonprofit hospitals have to carefully manage their for-profit contractors, particularly in the area of debt collection, to make sure the public's interests are being served. Would you agree?
Sure, I would definitely agree. I think this is one of the reasons why the Internal Revenue Service has begun to ask nonprofit hospitals to report what collection actions they or an authorized agent have undertaken. And it's very specific questions. Those questions were added for tax year 2010, but they were made optional for that tax year. This is the first year, tax year 2011, that hospitals will have to report that information. And I think it's just for the reason that you're saying. There is an inherent conflict of interest here.
Professor?
I absolutely agree with you. Historically, the reason why, in fact, we allowed hospitals and other organizations to have a charitable status is because we had sick people, and we know when there's sick people who are untreated, just as you mentioned earlier, it can become a public health nightmare. And so we want people who cannot afford treatment to be able to get treatment, and in exchange for that, we allow for a tax exemption status for hospitals. But there is a conflict of interest that does arise clearly when hospitals perform in more illusory than real ways with regard to providing charitable care.
It just seems to me that that there is a responsibility that the for-charity hospital has, and that it can't allow its relationship with the for-profit entity to compromise that mission.
I think that's absolutely right, and I think this has become a very complicated issue, not only in the state of Minnesota, but throughout the country as well. There are also some very significant information asymmetries that take place, so that individuals who need care and they seek emergency treatment believe, and in fact federal law provides for them to be able to get that care. Poor people who believe that they're being treated at a charitable hospital believe that they will be treated charitably. It's unfortunate when they arrive at our hospitals that we are providing tax exemption status for, in Minnesota taxpayers are paying for, when they're not getting that kind of quality of care. And I think we're all sensitive to the fact that this is a real challenge, how hospitals will recoup debt. So that we all know about, but it's the manner and place in which this all happens that I think makes this hearing incredibly important.
I think that's the case. Hospitals are in a crunch, and they have to be able to collect. And I think everyone agrees with that. No one here does not agree with that. And it's how you do it, and when, and where. Professor Goodwin, as you know, the Fair Debt Collection Practices Act is intended to protect consumers from unscrupulous debt collectors. However, the law doesn't cover all collection activities. Accretive has argued that the Fair Debt Collection Practices Act did not cover their revenue cycle employees working at Fairview. Do you agree with that assessment?
I disagree with that assessment. I think if you look at the law, the intent behind the law, and as I pointed out specific sections of the law, Accretive would certainly have been covered by this, and that their behavior certainly stands, in my opinion, as a violation of the law. I've read through all of the volumes that have been presented by written by the Minnesota Attorney General, and there are specific violations that are pointed out, both in terms of communication, how they communicated, when they communicated, deceptive practices in terms of what they did not disclose to the individuals who were seeking treatment at the hospitals, to inform them that they actually were debt collection agents, that they served a dual purpose and role. There were violations by the manner in which they sought payment from patients at bedside, and in ways that even my law students, non-law students, if I were talking to high school students and I showed them the statute and said, here's the conduct that's been alleged, has there been a violation, a high school student would say yes.
So that sounds like you're saying that the law is clear enough to hold bad actors accountable.
Certainly, that's true, but I also would say that there are ways in which the laws can be strengthened. I think that on the face of the law itself, as I've read some today, and you have other in my written testimony, there were clear violations of what the Attorney General's office has amassed in their investigation holds to be true, clear violations of the law. That said, what concerns me is that for consumers, there really isn't, there isn't the opportunity to be incentivized to even complain about this. At best, a consumer who wants to file under the FDCPA may at most recover $1,000. That's negligible. There's no significant disincentive for a company that's going to bring in tens of millions, if not hundreds of millions in revenue per year to do anything otherwise, if at best they're going to pay off $1,000 to a consumer who complains.
Well, in addition to the FDCPA, let's talk about privacy laws. Based on the evidence we've heard today, do you believe our federal health policy, privacy policy, that those laws should be strengthened to protect patients' privacy, and if so, how?
One of the issues that arose today involves the snatch and grab of the laptops, one in 7 corners, and I suppose that there have been a number of others, I think up to 9, that have been snatched and grabbed. And in these laptops, the data that's, first of all, there's been too much data that's been provided, but in addition, there's data that has not been encrypted. So I think that we can do more to strengthen HIPAA to provide for the advancements in technology that perhaps were not predicted at the time of HIPAA's passing.
Thank you. This question is for all the witnesses, so anyone chime in. One of the key things we've been struggling with all day is that hospitals need a way to collect from patients that is fair and reasonable and that doesn't interfere with patients getting the care that they need. Where do we strike that balance? Is there a responsible way for hospitals to collect on their debts without compromising the quality care of patients? And are there additional changes to federal law that you would recommend to achieve that balance?
Sure, I'll start. I think that those are exactly the right tensions to point out, but the truth is that there are ways that hospitals can collect on these debts without going bankrupt. Hospitals do this all the time. Part of the issue that does come up is really timing and place. What struck me from the testimony today was that it did not seem in the questions that patients were being asked about ability to pay or whether they would like to pay. I didn't hear at that moment a question about, are you concerned that you will not have an ability to pay? And the hospitals that we've worked with that have done this really well will ask those questions up front. If a patient is uninsured, if they're underinsured, if they express some difficulty about paying, in some places, if they are eligible for other kinds of programs, food stamps, Medicaid, Medicare, there can be some form of presumptive eligibility put in place for financial help under the hospital's policy. So that's a starting place, is to think about in the hospital, how are they communicating? What are the policies? What do they say about time and place? How are those being communicated to staff and reinforced to staff within the hospital through regular trainings? There are ways that that can happen. And then again, moving down the line, I do think that there are debt collection activities, because of the way that medical debt is unique, that should not be allowed for patients who are below certain income thresholds, for example, who've qualified for charity care, who have set up a payment plan, and they're at the max already. There are collections practices that I think should be outlawed as well. If you're looking at garnishing patients' wages or putting a lien on their primary residence, those are things that have very significant consequences. And right now, the burden is really on patients to advocate for themselves in these situations. I think the burden needs to shift to be more on hospitals. If they're going to engage in some of these activities, they need to ratchet up the internal controls that they're using before they move forward.
I would agree with that. Two things that I'd like to point out. The first is that we not lose sight of the Nuremberg Code or the Tuskegee experiments, these sort of anchoring moments in history that teach us about the ethical conduct that is expected of the medical community, whether we're talking about researchers, doctors, nurses, hospitals. And there are 4 principles that we learn and that are guided from those moments in history that we all continue to be shocked by. And they are beneficence, and that is about first, do no harm, that hospitals are about giving care. The second is about patient autonomy, and that being a priority. Social justice is also important, and informed consent. And I think one of the things that one hears through this investigation is how so many of those basic practices, what we expect dating back to Nuremberg, were just simply not taken seriously at all by Fairview in their relationship with Accretive Healthcare. In terms of thinking about the ways in which the law can move forward, one of the things that we haven't talked about is the use of criminal law. And I would commend you to consider the work of Professor Song Richardson. She's a person who's collaborated with me about the ways in which we need to take a much more serious look at the ways in which health laws are violated and research codes are violated, and the criminal law provides a very strong stick to check against behavior such as this, and I think we need to move in that direction. 2 more things that I would suggest, and that is we really do need better information sharing with patients, because there are information asymmetries, and what patients need to know about are the ways in which hospitals go about collecting their money, and why it's important that hospitals are in the shape that they are when they're looking to recoup losses. That's not really information that's shared with patients. They're expected to sign on a dotted line, but in terms of good quality information, it's simply not there. And one other point would be to take a very serious look at hospitals and their charitable status. We need to consider joint and several liability here, which is not a new concept in the law, but it is to say that when hospitals understand that they're working with parties that do badly, they too can get in trouble, not just the companies that they're working with.
Thank you. Ms. Ross.
I will have to say, echoing on what Michelle Goodwin just said here, I was struck when Mr. Moody and Mr. Kazarian were speaking about, especially Mr. Kazarian, about the types of things he said his company is supposed to do. And what struck me is you've got this supposedly beneficent community facility. Hospitals are there for the community. They're supposed to be. And you've got professionals who know their duty is first do no harm. You've got social workers. You've got people who could perform all of those duties that he was talking about in his for-profit business. So people who clearly understand HIPAA and know what they can and cannot share, who clearly would safeguard that information because they're healthcare professionals, caregivers in that institution. The hospital in which they work clearly understands that. Why on earth would you farm that out to another company? That does not make sense to me. What he talked about in the form of helping patients, I was really glad to hear, because patients do not have a clue. They are farmed out to talk to their insurance people. It depends on who you get that day, whether you get a real person on the phone. They can talk to the hospital personnel. The hospital usually says, go talk to your insurance person. So if they had some sort of coordinator within that hospital facility that could do that, that would be more ideal, I would think, than farming it out to someone else.
And I truly believe that Accretive did that service too, and that they did some as Mr. Kazarian said, that they help patients find insurance. But again, we're talking about balance, and we're talking about the right way and the right
And it's yet again
time.
another party to give that protected information to when it doesn't need
Exactly.
to be.
Well, thank you all for your testimony today. You're now excused.
Thank you very much.
Thank you.
Well, I want to thank all the witnesses today. In closing, I also want to thank the chairman and ranking members of the Senate Health Committee, Senators Harkin and Enzi, for allowing this hearing to take place. I'd like to also take this opportunity to once again thank each of the witnesses who testified here today. We have a healthcare system that is among the most expensive per patient in the world. I visited many hospitals across Minnesota, and as far as I'm concerned, we deliver some of the best health care, if not the best health care in this country. That is in no small part because of extraordinary hospitals like Fairview's and Alina's and Mayo's and others. Many hospitals are operating on smaller and smaller margins, and they need help to survive financially so they can serve their communities. A company like Accretive offers itself as a solution, a way for hospitals to get revenues that are owed to them. I get it. But it really seems like something went wrong here. Accretive cites in its response letter to me some very positive emails and comment cards and letters from Fairview patients expressing their gratitude for the help that they received in finding insurance and other ways to pay for their care. And I will read the first two. She was incredibly helpful in all caps, and provided me peace of mind in all caps. Next one, you were very efficient, you were compassionate, and asked me questions without just turning me away. You explained the hospital policy, but immediately looked into my situation. I think that's just great. And Ms. Ross, I think, spoke right at the end about the folks that do that. Here's the thing about that. I think that should be the norm. This is Minnesota. People in Minnesota are good at their jobs, and we are nothing if not nice. I would expect Minnesota healthcare employees to do a great job in very difficult circumstances. And these are very difficult circumstances. When people come to a hospital, it's usually a very stressful situation. Even in the most blessed occasions, the birth of a baby, even that can be very stressful. And very often hospital visits are made in more trying circumstances. You go to a hospital when you're sick or when you've been hurt and when you're at your most vulnerable. And the revenue cycle folks that were doing these jobs for Fairview had to exercise a lot of judgment. These jobs require not just sensitivity, but also the ability to make distinctions. Distinctions about when and how and where it is proper to ask a patient for money. It seems to me that there is a right way and a wrong way, and a right time and a wrong time to do these things. And to help your employees get it right means creating the right culture. We are all human beings, and human beings are not perfect. But leadership in the industry isn't just about providing the right software and the right processes. It's about providing thoughtful guidance It's about creating a culture where people err on the side of compassion. Minnesotans should be able to receive the health care they need when they need it. And when you or someone you love is sick or hurt, you shouldn't have to spend time worrying about some of the details we've been talking about here today, such as whether you or your loved one is being badgered for prepayment while they're writhing in pain, or whether that sensitive information you're giving to your doctor or nurse might not stay private. So I'm going to continue to look into these issues. This hearing is just is a beginning, not the end of my investigation. I'm going to think about everything I've heard here today. I'm going to look into whether we can do more to strengthen our laws, our federal laws, to protect patients. I'd also like to submit 4 statements for the record. These are from the Minnesota Hospital Association, the Teamsters, the Minnesota Nurses Association, and the PCD Foundation. We will hold the record open for 1 week for submission of questions for the witnesses and other materials. This hearing is adjourned.